Hey YouTube. Okay, it's about 8 o'clock in the morning on 9/2/2010. Today my workout will not be, I won't be working out because Sunday and Mondays are my days off. And I'm going to read from, it's called Voice of Revolution. It's more like a socialist paper, but actually, Marxist-Leninist organization, so it's kind of a communist one, but they actually do have a lot of wonderful articles in here that really make me that really resonate with me, and one of them being "Time for a Democracy of Our Own Making" is what it says there, and then it says by Brendan Fischer, July 19th 2012, PR Watch. Headline is "Second Judge Finds Wisconsin's Voter ID Law Unconstitutional." A Wisconsin judge has found that the state's American Legislative Exchange Council-inspired voter ID restriction imposes an unconstitutional burden on the right to vote, writing that the law tells more than 300,000 Wisconsin voters who do not now have an acceptable form of photo identification that they cannot vote unless they first obtain a photo ID card. That is a lot of people, and most of them are already registered voters, wrote Dane County Judge David Flanagan, making permanent the injunction he issued against the law in March. In his decision, Judge Flanagan found that the potential burden on voters from Wisconsin's Voter ID Law, Act 23, was great, but the risk of voter fraud very limited. Since 2004, voter fraud investigations have been undertaken by the Milwaukee Police Department, by the Mayor of Milwaukee, and by the Wisconsin Department of Justice, working with various county prosecutors, working through the Attorney General's Election Fraud Task Force. He wrote, "None of these efforts have produced a prosecution of a voter fraud violation that would have been prevented by the voter ID requirements of Act 23. On balance, the benefits of the law stopping the non-existent voter fraud did not outweigh the costs of disenfranchising more than 300,000 Wisconsin voters. Act 23 addresses a problem which is very limited, if indeed it exists." Flanagan wrote, "Given the sacred fundamental interest at issue, it is clear that Act 23, while perhaps addressing a legitimate concern, is not sufficiently narrow to avoid needless and significant impairment of the right to vote. Additionally, although the law provides for a voter identification card at no charge, Judge Flanagan found that obtaining the ID can be easily frustrating, complex, and time-consuming process that can require the expenditure of an amount of money that is significant for an eligible voter who is indigent." The lawsuit was filed by a Milwaukee chapter of the NAACP and the Milwaukee-based immigrants group Voces de la Frontera. Law will not be in place in November. Earlier this year, Dane County District Court Judge Richard Neese issued a separate opinion in a case filed by the League of Women Voters, also invalidating the state's ALEC-inspired voter ID law. Although Wisconsin General J.B. Van Hollen is appealing Neese's ruling and will likely appeal Judge Flanagan's decision, the new voter ID requirements are not expected to be in place for the November 2012 elections. Supporters of the law need to get both orders lifted for voter ID to be reinstated, and the Wisconsin Supreme Court has declined to take up the cases prematurely. Although the U.S. Supreme Court held in Crawford versus Marion County Board of Elections that Indiana's relatively similar voter ID did not violate the U.S. Constitution, the cases considered by Judges Flanagan and Neese were brought under the Wisconsin Constitution, which, unlike the U.S. Constitution, expressly protects the right to vote. Wisconsin's voter ID law is also stricter than Indiana's, and evidence indicate that it will place more burdens on a greater number of people. Additionally, Judge Flanagan found that plaintiffs in Wisconsin had established a much more extensive and credible factual record than plaintiffs in the Crawford case. Voter ID has ALEC roots. Wisconsin's voter ID law bears many elements of the ALEC Model Voter ID Act, as do dozens of voter ID bills that have been moving in state legislatures in recent years. Republican Representative Robin Vos, the ALEC state co-chair in Wisconsin, spearheaded the effort to pass the bill in 2011, which reflects key elements of the ALEC model. Voter ID Act. In June, Voss and another legislator sought to intervene in the appeal of Judge Nice's decision, striking down the law as unconstitutional, but refused to disclose who was funding their legal fees. After Wisconsin's Ethics Board advised that accepting free legal services would run afoul of Wisconsin law, Wisconsin ethics rules prohibit legislators from accepting anything of value that might influence their official judgment. Voss pulled his name from the case, but still refused to say who had been paying his legal fees. Days later, it was confirmed that Republican National Committee had been secretly bankrolling the effort to intervene in this case. So also, I will be looking for that opinion by Judge Nice, and by Judge Flanagan. So I will definitely be taking a look at both those rulings for Wisconsin's Act 23 law and Alec Roots' American Legislative Exchange Council, which is a right-leaning group that just, it makes me sick just to think of them. So excuse me while I throw up. Have a great day, YouTube. See you later.